Looks like the parties are ready, and the high school kids are gone, so you can tell us where you went to high school if you want to, but you don't have to. We'll assume you did graduate. The case of Chandler versus Iowa Department of Corrections is now before the court, and it's my understanding Mr. Jim Duff is going to argue for the appellant.
May it please the court. Counsel, I am a little disappointed because I do remember my fight song. It was Hail to the Victors Valiant, which is the University of Michigan's fight song. We just inserted Dowling Catholic instead of Wolverines.
All right. Thank you for sharing. Go ahead.
Thank you, Your Honors. Today we are asking that, or my name is Jim Duff and I represent the plaintiff appellants in this case, and we're asking that the district or the court reverse the district court's ruling and hold that we do have a private right of action under 80F.1, specifically subsection 13. And this case really comes down to just, does the legislature mean what they say when they say what they mean? And in the newly amended subsection 13, they state that an officer shall have the right to bring a cause of action against any person, group of persons, organization, or corporation arising from the filing of a false complaint against the officer or any other violation of this chapter, and this chapter being 80F.1. And then it defines additional damages that are available that would not have been available under the common law. And in light of this express language, we think it's clear that the legislature did expressly create a new cause of action for officers for violations of their rights under Chapter 80F.1. And I do want to address briefly the Dowdovich decision, because that did address the previous version of 80F.1, and I do believe Dowdovich was correctly decided, written by Justice Mansfield.
As far as I'm concerned, because I think it's irrelevant, so.
Right, well, there are a couple pieces that I might come back to, but I understand, Your Honor. And I think it's important here, we cited to a number of cases and statutes where this court has held an express creation of a statute. They're very similar, and in some cases, the language in 80F.13 is stronger, with the use of the word shall instead of may.
You know, we have to say, when you say this, the legislature says what it means and it means what it says, it also is out there that if you're going to not have 17A apply, it has to be very clearly written. What about subsection 19, the administrative remedy? I mean, sometimes I wonder if you're looking at 13 in isolation.
Your Honor, and I think the best analogy for that would be this court's decision in Walsh v. Wallert, because 80F.15 is very similar to 78.28. 78.28 creates a right for a civil cause of action. It also states that you can have this administrative procedure just like 80F.1. 78.28 does not have the express language that says you can bring the civil cause of action regardless of what we said in that introductory paragraph of 17A.19. Regardless, this court stated that when you expressly create a cause of action, you have a choice of remedies.
Some express language in those whistleblower cases about 17A, and doesn't the whistleblower statute specifically reference that? And wasn't that part of the hook that the court used in saying you don't have to go down that route?
So, Your Honor, and I might be misremembering, but I believe in Walsh v. Wallert, the key linchpin that this court hung its analysis on was the fact that there was a statute provision that said you shall have the right to bring a civil cause of action. I don't believe that 78.28, because I think 17A.19 has an introductory unnumbered paragraph that states that this is the exclusive remedy unless you reference this statute by name. So, and there's some language that was included in there. I don't believe 78.28 includes that language. It does reference 17A by name, just like 80F does, but it doesn't say that you have it. It doesn't expressly state you have a choice of remedies.
And I previously misunderstood that issue, but I do think there is reference, though, in the whistleblower statute to 17A, correct? Yeah, okay, and not here.
I don't know if it necessarily references 17A with the citation, but it does reference administrative procedures and administrative appeals, which would be 17A. So, yes, Your Honor, it does not use the name of the statute, but it does reference the administrative appeals.
I mean, just looking at the different words that are used in 80F.1. So the provision you're quoting talks about Officers shall have a right to bring a cause of action against any person, group of persons, organization, or corporation for damages. And you're saying person includes the Department of Corrections here, right? But that, I mean, if it was that all-encompassing definition of person that's at the beginning of, you know, the Iowa Code, then why would they name organization, corporation as well? That doesn't make sense.
I think I understand where you're going with this argument too, is that it does seem, if we adopt the broad definition of person, it seems we're rendering that term corporation superfluous. I don't think organization is mentioned in it, but it's certainly implied with the broad definition in Chapter 4. I think the bigger problem, though, is if we adopt the state's interpretation and that person does not include the definition in 4.1, which would be the state and these other employing agencies, you're actually rendering the entire phrase "or any other violation of this chapter" superfluous, because most of the rights, with the exception of the false complaint, are only enforceable against the officer's employer, which are almost exclusively.
I have about 13. It says filing a false complaint or any other violations chapter. Where in the chapter does it make it a violation to file a false complaint?
Well, in subsection 13 would be the only place, but this.
So, I mean, it's kind of an oddly, looks like maybe a rush job by the legislature, right?
Necessarily speculate about the legislature rushing, but certainly including the word corporation could have been an oversight, because clearly they're trying to broaden the definition or the scope of who this applies to.
Then it also says group of persons. If you wouldn't, group of persons makes it sound like person is referring to a actual physical person, not a metaphysical person like an agency or a corporation or something like that, doesn't it?
I think the group of persons language would reference more of like an unincorporated social group, something like Black Lives Matter, something like that, where there's not necessarily a incorporation or a formal legal structure, but they're clearly a group of persons. I think that goes to the point, though, is that this language was intended to broaden who these complaints can go against. The previous language simply said citizen, which made it very clear that they didn't think that these employers could be sued. Going back to Chapter 4.1, though, the definition of person, and I think it's only in the definition of person, states that unless otherwise provided by law, and then lists what the definition would apply there. And I wanted to bring the court's attention to the case of Aaron's versus Iowa Select Farms, 556 Northwest 2nd, 812. I don't believe this was cited in our briefing, and I apologize for that. But in that case, the court considered the definition of person in Chapter 4.1, and specifically that language, unless otherwise provided by law. And in that case, the court held, I think it was Chapter 654B, that the definition of person from 4.1 applied because 654B did not provide an alternate definition of person. I think.
Did it just say person and go on, or did it have a list like this does where it says a person, group of persons, organizations, or corporations?
Your Honor, I don't recall. I do recall that there was a definition of natural person in there that was not quite the same as person.
Is when you talk about or otherwise provided by law, what does that mean? Is this otherwise provided by law when it says person, group of persons, organization, or corporation? Or does it need to say person, the definition of person is?
In Aaron's case, it would strongly imply that it was a definition section, was that what they were looking for. And there is a definition section in ADF.1, which does not redefine person in any ways, which looking at those cases in conjunction with this definition section would strongly imply that the 4.1 definition would apply in this case.
Department of Corrections, is it in this provision, is it a person, an organization, or a corporation?
Or Chapter 4.1's broader definition of the word person.
That agency, employing the officers, employing agency, these are all referenced in sections 20, 21, 22. They're not spelled out in section 13. If they meant employing agency, why wouldn't they have listed it there?
I think they would not have listed it there because they used the word person, and the legislature knows that they've defined it broadly. It is a little odd, I will give that.
Corporation, right? Because corporation is already baked into 4.120.
I would say sloppy drafting, Your Honor. But again, I think going back to that, reading person narrowly would also have some additional odd effects in that you could sue then a corporation, but you couldn't sue an LLC. You couldn't sue a partnership. You couldn't sue a sole proprietorship. It doesn't make a lot of sense that that would be what they're specifically going towards.
That might be an organization.
Possibly.
That. Well,
Defined, so I guess technically the state could be an organization as well. I think it's cleaner to just say that they're a person since we have that definition from the legislature.
Well, on 4.1, I agree with you that we have that definition, but the heading for 4.1 is rules, and the introductory is that we apply these rules, but only, need my glass, unless such construction would be inconsistent with the manifest intent of the General Assembly or repugnant to the context of the statute. So you're not saying they're absolutely binding in this situation. They're more an instructive source, I would say.
It make no sense applied in the situation, like you said. You don't have to apply them, but I would actually argue that not applying that definition of person would be inconsistent with the whole scope of the statute, which was to provide, going back to Dowdovich, which was correct, that the purpose of ADF.1 was to provide rights for these officers vis-a-vis their employers. That's still the case. While the statute was amended significantly, it added additional rights for these employees against their employers. It would be
Addressing Dowdovich, isn't it strange that they didn't say employing agency in that list?
They certainly could have stated employing agency. However, if you look at, I was looking at the amendments recently here, subsection 18 was added to. So there was part of that first half of 18 was there, and it uses the term as well. I don't think it says employing agency, but maybe agencies that employ officers. And they added to section 18 and then added 19, 20, and 21. So I think what the legislature was doing was just mirroring that language in that most recent section, probably not thinking that this would be used to maybe undermine the intent that these employers can be held liable. Because the whole point of this, though, all of these rights, with the exception of the filing of a false complaint, really can only be enforced against their employer. So to allow an officer to sue for a violation of the chapter but accept the employer out of it simply would not be consistent with the intent or the scope of this chapter. And I did want to, I don't know if the court wants me to address the standing argument at all. I do believe we have standing to bring this claim in the event that this is an issue that the court is considering. There is a U.S. Supreme Court case, again, that did not make it into our brief that I think is very instructive. It's Federal Election Commission versus Akins. It's 524 U.S. 11 from 1998. And in that case, it was a group of voters suing because they could not get access to certain documents under an election law, a sunshine law. And the Supreme Court held that the inability to obtain information that Congress has decided to make public is a sufficient injury in fact to satisfy Article 3 standing, also satisfied the elevated burden of prudential standing. And that's very similar here. We have documents that our clients requested and the legislature stated they are entitled to. The absence or the lack of ability to get those documents is sufficient to denote standing on us. And I
What does subsection 19 do now?
19, I apologize, I don't have that in front of me, Your Honor.
The section that provides for an allegation of a violation of this section may be raised and given due consideration in any properly authorized grievance or appeal.
Simply be a rule of evidence or a way that these administrative law judges can interpret the evidence, sort of similar to a spoliation instruction in that you didn't even follow your own rules we can read some inferences into that. Again, that would only be applying, though, through the administrative process, which
But that subsection 19 was not changed by that 2021 amendment? I think I am correct. So my point is, it was there and it's still there. Okay.
was. If your honors have no further questions, I'm prepared to see.
We'll give you a break. Ms. Stoltze, and now you do have to say where you went to high school because everybody else has.
Very good. I was going to do so anyway. Breanne Stoltze, excuse me, on behalf of the Department of Corrections, I went to Roosevelt High School here in Des Moines. Our fight song was, I believe, just the Roosevelt fight song, although I'm sure my friends in band and color guard will be correcting me if I am wrong about that.
Yes, yes.
In band, but most of my friends were. So I do know we had a fight song.
You may proceed.
Yes, and Breanne Stoltze on behalf of the Department of Corrections. When the legislature creates a private right of action in an area normally reserved for agency law, it not only speaks clearly, but the law requires it to use specific, explicit language exempting that cause of action from the exclusivity requirements contained in 17A.19. The legislature did not do so when it amended the Peace Officers' Bill of Rights in 2021, and that omission is fatal. So, to find otherwise, frankly, misreads ADF.1, and in so doing, transforms this court into first-level personnel boards for procedural disputes in disciplinary proceedings. Any sort of reading of subsection 13 suffers from three main flaws. First, as I noted, it omits the necessary language in 17A.19. It overstates the effect of the amendments made to subsection 13 in 2021, and requires reading that statute in isolation without regard to the unchanged terms of subsection 19.
Been affected by the 2021 amendment?
Absolutely correct. So any analysis as far as the effect of subsection 19, I believe, is unchanged from Detovic, that it still provides those administrative remedies for these disciplinary proceedings, and by extension, any procedural violations that would occur as part of those.
Give me an example of what subsection 13 does do. What kind of lawsuit can an officer file under section 13, subsection 13?
Certainly, you'd have the same sort of kind of false complaints against kind of this expanded group of plaintiffs that we had before. I also believe, as noted in my friend on the other side's argument, there isn't a direct reference to false complaints, but there is in subsection 12 a reference to 718.6, which is Iowa's statute for false complaints. So conceivably, the legislature meant to encompass, say, a misleading complaint, a false light type complaint, or any future expansion of 17.8.6. This would certainly make sense in light of the context in which the rest of these amendments were made. This was kind of made in Senate File 342, which contained not only the changes to ADF.1, but also changes to, say, other criminal statutes, expanding criminal liability for those who harass peace officers or engage in official processes. It's also possible that the other violation language, given that it says other violations of this chapter, as opposed to subsection 19, which says other violations of this section, that suggests it might be referring to the only other part of chapter ADF that isn't in ADF.1, which would be ADF.2, which deals with unfounded public offense violations or allegations against a police officer.
To allow, and I see your argument. You're saying a violation of 718.6 might be deemed a violation of ADF.1 because of it's incorporated in subsection 12. And then the purpose of 13 is to allow the officer to have a private right of action for damages against whoever brought the false complaint. That's what you're saying?
and that the other amendment to changing citizen in the prior version to include a person, group of persons, organization, or corporation expands that kind of group of plaintiffs to include not just people that might be non-citizens, especially given that you had folks coming in from out of state to engage in some of these unlawful demonstrations, but also, say, an advocacy organization that might bring a false complaint. But the through line is that the intention and the focus throughout all of Senate File 352 is to address issues that were brought on by outside entities that might interfere with police conduct.
I want to take you back to the other violations of this chapter. You talked about subsection 12 kind of encompasses other things, but I'm not sure that that necessarily is a violation of subsection 12 when it talks about what the investigating officer is supposed to be doing. And so if it allows a claim for any other violation of this chapter, who could violate the provisions of Chapter 80F? And like you said, there's only two other provisions, and it talks about reimbursement of, what was it, reimbursement of defense costs or standard of proof. It's kind of hard to, those are kind of would be odd violations. But so who else could violate the provisions of this chapter besides the employing agency or one of its employees?
As far as the procedural violations, I think at that point we are, in fact, outside the ambit of subsection 13, given that the rest of that statute and the context in which it was amended suggests we're talking about outside entities. So to the extent we're talking about the
Legislature mean then when it said other violations of this chapter? That's a pretty broad phrase.
first, I would say that it's meant to discuss kind of it's discussed in relation to and filing of false complaints. Regardless, I know my friend on the other side takes issue with which interpretive canon I'm using, but whether you use astudum generis, the associated words canon, surplusage, the idea and any other violation of this chapter is necessarily informed by the phrase, the filing of a false complaint. Otherwise, the provision would just read any.
The idea that filing a false claim actually is not a violation of this chapter necessarily. That's why they included that language to begin with, is that to give that cause of action when someone does file a complaint, because filing the complaint itself is not a violation of this chapter. I'm struggling with the any other violation. Any is a very broad term, other than the relation back. And then a related question is, an individual that is employed by the employing agency, so one of the investigating officers is a person. So could the plaintiffs have brought a claim against one of the people involved in the investigation as a person for violating a provision of this chapter?
To the extent that an officer was bringing a complaint against an officer in their official capacity for actions in their official capacity, that is construed under Iowa law as a complaint against the state itself. So you're kind of back in that situation. It's conceivable that there could be a challenge for actions employer, individual acting in their individual capacity. Although at that point, I struggle to see if we're talking about these procedural violations, how someone's acting in their individual capacity when, say, administering a polygraph or determining when certain records are provided. Under certain circumstances, it's possible, but not under the circumstances of this case.
Oh, go ahead. Just one additional question. In 2022, they added subsection 24, considering the Brady-Giglio list. And subsection or paragraph I of that specifically says that this subsection does not create a private cause of action against a prosecuting agency or an employee of the prosecuting agency. Does that, I know it was enacted after this particular provision was, but does that inform or suggest that the General Assembly saw chapter or provision 13 as broader than what you're suggesting?
I don't believe so, in part because we're talking about the prosecuting entity more likely being not that officer's employee. You're talking about someone at the state attorney's office, and you'd also still be running into the 17A.19 issue, where to remove something that is traditionally under the ambit of agency action from that judicial review exclusivity, you need to reference 17A.19 by name, and whatever other changes occurred in subsection 13, there is no reference to 17A.19 in ADF. And
Walsh case.
I would distinguish it through both text, structure, and the history of ADF. I think the best summary is, I think the language Justice May might have been looking for is at 525 of Walsh, head note 4, where it discusses 70A.28 is, quote, an unusual case in which we have a statute that expressly creates an independent cause of action in the alternative to administrative remedies under Chapter 17A. And in that case, in 70A.28, you have subsection 5, which provides the civil remedy, and the immediate following section, subsection 6, says that one may also pursue administrative remedies under 17A. That may also language is missing from ADF. There is also no reference to 17.A at all. The structure is very different. And if you look at the history of 70A, originally enacted as 79.28, Justice Apple discusses this history at 525 of the opinion as well. When enacted in 1984, it was simply a criminal provision with a civil remedy added 5 years later. There were no administrative remedies at all until 8A was amended in 2003, and then the current subsection 6 was later added to provide this symmetry of remedies between merit and non-merit employees. So you kind of have the opposite situation where the civil remedy clearly existed with administrative remedies brought in on the back end, and that's not what we have here in ADF.
Of the absence of the term employing agency in ADF 13.
That is a very strong indicator that this is not meant to encompass an employing agency, especially when we get into the kind of sovereign immunity concerns that might be implicated by a complaint against, like here, the Department of Corrections. And in fact, as we note in the brief, I'd point the court to the statutory history where agency was included in subsection 13 in the 2007 draft and was expressly removed by the legislature prior to enactment. This suggests certainly at the time of enactment it wasn't meant to apply to agency. It also suggests that the legislature knew how to create a cause of action against the employing agency and expressly chose not to do so with its 2021 amendments.
Investigation documents relating to an alleged false complaint. Does Chapter 80 F give them a right to see those?
Subsection 9 does, and as the department made clear to the plaintiffs in this case, they did have the ability to obtain it through the PERB process. I suppose now that would be the Employment Appeal Board process. And the plaintiffs here chose not to pursue that process. Instead, they chose, in all three cases, this private right of action or this private class action. And in the case of Mr. Jones, he pursued a Chapter 20 protected practice complaints, but at no point did they follow the procedure that the department had set up that would have provided them this file.
Is withholding those records sought under ADF one of these other violations that gives them a direct right of action to sue?
Not believe so, because again, when we're looking at subsection 13, we look at the parties that that's against, and we also look at kind of the nature generally of kind of the false complaint violation where we're talking about an outside entity, and the notion that we have subsection 19, which provides a very explicit remedy through the administrative process, and then you also have the lack of language from 17A.19. And then to just, unless there are any other questions on the statutory interpretation piece, I'd just like to briefly address the standing argument. And I think there's some kind of a disconnect between kind of our argument and I think plaintiff's interpretation of our argument. We aren't arguing a lack of injury, we're asserting a lack of redressability. essentially that the inability to receive these files was essentially of plaintiff's own making. They had a process through kind of that the department had set out for them saying, if you want these files, here's how you do it. They chose not to. So really, their complaint is kind of with their own actions. And, as we note in the brief.
Failure to mitigate damages or something?
Somewhat, I'd say it's more like trying to create their own damages. So they are kind of the result of their own injury. So.
The state simply turned these records over.
The state's, or at least the Department of Corrections, policy is to wait until there's a PERB appeal. There might be some kind of concern that they want to make sure, just not only for administrative efficiency, but a desire to minimize disruptions against witnesses in these complaints, that they're being obtained as part of an official kind of appeal process. So unless there are any other questions, I would urge the court to affirm the district court in this case and find there's no private right of action under ADF.1.
You may continue.
Thank you, Your Honor. I wanted to briefly address something that I don't think has been mentioned yet, and that is the underlying purpose of why we brought this action in the first place. This was not an action seeking to recover. We have a damages claim. That is not the gravamen of what we want. What we want is an injunction against the state and the Department of Corrections requiring them to timely produce these investigative files. We brought the ADF claim because it has the direct cause of action in there. We also brought an accompanying injunctive relief claim. What we want is that the Department of Corrections will produce these documents within 7 or 14 days, whatever the court is comfortable with.
Told us about another path that you didn't take. Could you address that?
I think the facts are a little bit unsettled as to whether or not they actually get the documents when they file the PERB hearing or the PERB grievance. But the point, though, of Section 9 is not that they have to file a PERB grievance before they can get those documents. The point is that they should have the documents before they make that decision. There's a lot of reasons that an employee may not want to go through with the PERB. In particular, they might lose because they have really good evidence against them. Moving on might help patch up some hard feelings with the supervisors instead of continuing that grievance process. There's also legal fees that are accompanied by the process going through PERB, which you can do it pro se, but as everybody on this bench knows, it's always better to have a lawyer. There's a lot of reasons, and the legislature expressly stated that those documents should be timely provided upon issuance of the discipline, not upon filing of the PERB complaint.
Let's say, it seems you could skin this cat a different way. I'm just thinking, I understand it's a legitimate concern. If hypothetically you didn't prevail in this case, couldn't you go and ask for like a whatever it is, declaratory ruling, declaratory order from the DOC?
A request, that's our count 2 in our amended petition, Your Honor, and that was dismissed as well because of administrative exhaustion requirements. That's why we brought the injunctive relief claim with the ADF claim, was because the ADF helps us get around.
Didn't do that. I'm sorry, I forgot that you had done that.
Sure, this is an exhaustion or it's more of an exclusive remedy issue. I don't think this is a situation where we can go get a right to sue letter.
Go to the agency and ask the agency, we think you should interpret the statute to mean that, whenever you've gotten to this point, the corrections officer is entitled to the investigative file, and you should interpret that in all cases. That's what it strikes me, sort of it's more an administrative law question. It might be a way to solve it, right?
There's 2 issues with that. One is that that has been tried, and the court denied that motion because the documents were produced already once the PERB hearing was filed. Essentially, it was mooted at that point. So this is one of those things that's capable of repetition while evading review. Additionally, I would agree with you. This is more of a procedural violation, except we have a statute that says they have to produce these documents when requested, and then we have a statute that says they can bring this action in state court. So I think we did consider that, and we rejected that opportunity because the other issue is an administrative law judge saying, here's what the rule is not the same as having an order from a court saying, here's what the department has to do, and if you don't do it, you're violating the court's order. Because we already think that it was clear the department was violating the law when they refused to give these documents, and that didn't stop them. So we wanted an order from the court with actual teeth for continuing violations. And that is the thing I wanted to address, was this wasn't a case where we're going to be asking for hundreds of thousands of dollars in damages. What we want is injunctive relief. We want an order, and it's why we brought this as a class action instead of individually. We wanted this to apply to every member of the Department of Corrections, every officer who makes these requests, because, and I think in our petition it does lay out, this was not just an isolated problem with these 3 individuals. This is a problem we saw all across the officers of this state not being given access to those files when they requested them. And it's something that they have a right to. It's something that they need to defend themselves at these additional grievance stages and also the additional PERB stages. That's another issue, is there's more than one stage of grievance. They could successfully defend themselves at the grievance stage without even having to file a PERB if they're given these documents. It's a bit speculative since we don't actually have the documents, but it's just a fundamental principle of due process that if you're going to be accusing somebody of something, they have a right to see the evidence against them. And it's for these reasons that we think this statute is clear. It creates an express cause of action. These rights are enforceable against the employers because they're exclusively rights that can be enforced against the employers. And we would ask that the court reverse the district court's judgment. Thank you.
Of Chandler versus Iowa Department of Corrections is hereby submitted. The court is going to leave the bench for just a few minutes, a quick break while the next case gets ready, and we will reconvene for the case of Hunter 3 Farms versus Hunter and others.